So we have quite some ground to cover this morning because to understand what's going on today in Israel, we need to go back not really to January 4th, where the crisis that we're in officially started, but something like 25 years ago, or even 30 years ago. There is a little bit of a controversy on where it starts, when major changes began to happen in Israeli legal system. What I'm going to do today, I'm going to divide our conversation to three sections. First, I want to provide a general overview or context on what's going on in Israel in the past 7 months, what has been put on the table, what is part of the, what some people call judicial reform, and some people call judicial overhaul, and some people call a coup. So we're going to give a general framework of what's on the table, the general timeline, and then we're going to dive in or zoom in to the topic of the day, which some of you might have heard about. This is why all of the people have been marching to Jerusalem. This is why there are tents now in the Sakar Park, and people are marching to the Knesset, what the bill that's about to be legislated in the next 24 to 48 hours, with the somewhat technical and obscure name, the reasonableness annulment. Okay, so we're going to talk about that, and then I want to go even broader, but in some ways more focused, and tell you that even if Israel were to find an agreement, a compromise of some sort on the reasonableness doctrine, and even if we were to miraculously form an agreement on all of the topics that emerged and surfaced on January 4th, I'm going to say in a minute what happened on January 4th, we will not be done. And to actually solve the crisis where we are now, we will need to go, unfortunately, or maybe fortunately, that depends on perspective, much broader. So the third and last part of my talk will create a roadmap for a path forward. We're going to also talk about solutions. Okay, so let's start with general framework. What happened on January 4th, 2023? Minister of Justice Yariv Levin held a press conference in which he announced his plan as Minister of Justice, the freshly minted Minister of Justice of the most recent Netanyahu government. What are his plans for his term in office? In this press conference, Minister of Justice Levin announced what he called the first part of a 4-stage plan to conduct a major reform in the justice system. That first part, and I should bracket, nobody, including Mr. Levin, ever said what the subsequent 2, 3, 4 parts are, so we don't know. But that first part consisted of 9 different major changes to Israeli legal system, encompassing topics from the reasonableness clause that we will discuss in a minute, to how the role of government legal councils is defined in Israel, to how the government gets represented in courts when it is when it needs to do litigation in court, to maybe the most notorious or controversial, how judges get selected in Israel, or what some of you might have come to know, the controversy over the Judicial Appointments Committee. So these were 9 very major topics, and the plan that Levin announced that day was not coming out of the blue. This is a long-term commitment of Mr. Levin, and it springs from something like 25 to 30 years controversy over Israel's legal system more generally, and specifically the relationship between Israel's High Court of Justice, the equivalent of the American Supreme Court in some ways, I'll talk about differences in a bit, and the elected branches, the Israeli Knesset, the parliament, and the government, the executive branch. I want to say a little bit about the relationship between the government and the Knesset, because this is a very different model from the American model. Here in America, I'm just talking federal system for now. Every state runs its affairs differently, although there are lots of similarities. But if we're looking at the federal system, when you go to vote, you cast one ballot for the president and one ballot, typically lots of ballots, for your representatives in Congress. And of course, your state representatives. Therefore, what is created in America are two different, entirely independent, executive and legislature. Israel runs a very different democratic model. We belong to the family of democratic systems that run parliamentary democracies. In parliamentary democracies, typically, the person or the cabinet running the executive are drawn from the parliament. And so in Israel, in order for the executive to be formed, the prime minister and his government, typically called cabinet or coalition government, needs to form a coalition in parliament of at least 61, half plus one, of Israel's Knesset members. As a result, in Israel, the executive and the legislator are never independent. They're always dependent on each other. And so although we have two branches, an executive and a legislator, there is no separation of powers between them. And what is decided in the coalition government, in the cabinet, typically gets legislated in the Knesset. In fact, 90% of laws in Israel have started out as proposals by the government, okay, by the cabinet. So when I'm saying there is a long controversy on the relationship between the judiciary in Israel and the elected branches, it's not between the sort of three branches altogether, but between the cabinet and the coalition government that rules the Knesset, and on the one hand, and the court on the other hand. That conflict, as I said, probably dates to the late 80s and early 90s, results from a slow but steady expansion of the powers of the Supreme Court over that time, both by more legislation in the Knesset providing more powers to the court, and by the court interpreting and making use of these powers. Now, when Minister of Justice Yariv Levin announced on January 4th that he plans to do a major shift in this system of powers, his main focus was on limiting the ability of the court to review both laws of the Knesset and decisions and policy acts of the government. The way he sought to do it involved very different, sort of a bucket or a package of methods. One of them was to directly control the Judicial Appointment Committee, such that the cabinet will be able to alone appoint justices to the Supreme Court. And again, I know it's confusing, but remember that here, when justices get appointed to the Supreme Court, this has to be done with a collaboration of two independently elected branches of government. The president appoints, the Senate confirms, and as we know, this sometimes gets difficult. The president does not necessarily have a majority in the Senate. In Israel, that's not the case, right? Because the prime minister of the cabinet always have a majority in the Knesset. So when Minister of Justice Yariv Levin wanted to take over the Judicial Appointment Committee, one of the major implications is that the executive will directly manage to control the way justices get elected. In addition to that, there were additional changes that were put on the table, for example, to make it much more difficult for the Supreme Court to declare bills passed by the Knesset as void. So this is called typically constitutionality review. This is something that the American Supreme Court is doing as well. Maybe some of you like the results of that, some of you don't. Well, in Israel, sometimes we like the results of that, sometimes we don't. Minister of Justice Yariv Levin wanted to make that much more harder for the court to be able to declare laws unconstitutional. And one of the proposals that he put forth, in addition to controlling the appointment of justices, is to declare a supermajority in the Supreme Court to declare laws invalid. And conveniently, the number of justices that the current government was able to appoint to the bench is exactly the number of justices that under the reform would be able to prevent a majority of the Supreme Court to declare a law invalid. So as a general framework, these are the major components of the package that Minister of Justice Levin put on the table on January 4th. Little did Minister of Justice Levin and the coalition government anticipate the reaction that will come from Israeli public. Large segments of the population, according to surveys for a very steady period, very consistently, probably something like 60% to 70% of the public, including at least 40% of people who voted for the current coalition government, said that they don't want this reform, and they didn't vote on that and took to the streets. You have seen photos of these events time and time again, I'm sure. The sequence of events that followed was much more complicated, though. Behind the scenes started negotiations in response to this public uproar about ways to potentially create responsible set of reforms. As I said, in many ways, Levin's proposals were not entirely new. There was legal controversy on these topics for a long time, and many legal experts had different views on how to manage them, and there was thought that maybe there will be some kind of ability to reach some kind of responsible compromise that will not make the government so powerful without removing all of the checks introduced by the Supreme Court. Maybe there will be ways to create something more balanced, removing some checks, introducing other checks in place of these checks. In the middle of March, about 2 months and a half after Levin first announced his plan, there was a very big event, maybe some of you remember, where Minister of Defense Yoav Gallant stood up and said that he objects the reform because of the massive waves that's already started back then of pilots, army officers, and so on, saying that they will refuse to serve in a country that's losing its democratic shape. Minister of Defense Gallant stood in front of the cameras and said that he objects to the reform, and he calls for suspension of the legislation and enactment only by broad consensus. In response, the Prime Minister, Mr. Netanyahu, fired Mr. Gallant, and thousands of people took to the streets spontaneously. The day after, the entire state went into general strike. That was a crossroads. After that date, even though Mr. Netanyahu never publicly announced a withdrawal of his decision to fire Mr. Gallant stayed as part of the cabinet, continued to lead Israel's Minister of Defense, and the legislation was halted for a few months, and negotiations started publicly under the auspices of Israel's president, Mr. Isaac Herzog, who just visited the US this week. As many of you know, a president in Israel is just a symbolic, ceremonial figure. He doesn't have any actual legal powers, but he offered himself as an arbitrator to try and broker some compromise between the parties. That process started at the late March, beginning of April. There was Passover in the middle, so this sort of started at the end of Passover, lasted until about mid-June, when the conversations broke, exploded. There is, of course, There are, of course, different narratives on why and whose blame that was. But what happened as a result is that a few days after the negotiations broke and no agreement was brokered, the coalition decided to single-handedly or unilaterally move forward with legislating, for now at least, one part of Mr. Levine's broad, big, ambitious plan, the reasonableness doctrine. Okay, so this is a sort of long, condensed version of the sequence of events that brought us to this moment. And this process has been going on, this unilateral process of legislation, for the past 3 weeks or so. Okay, so what's reasonableness? Okay, so the reasonableness doctrine is actually a staple of almost every common law system. Common law systems are systems that emerge from England. So both Israel and the US have emerged from the English legal system, and there are actually many states in the United States that have something that resembles the reasonableness doctrine. The origins of the reasonableness doctrine is in the legal rule that the government cannot act in ways that are arbitrary and capricious. The government is the representative of the public. It is a trustee of public interest. We expect it, and so it shall act in ways that meets the highest levels of professionalism, of fairness, and of rationality. This all sounds very rational, right? There is only one main problem, and that is that often it's actually quite hard to know, both for a court and for a government, what's the most rational decision to do at a certain point in time. Now, rationality and reasonableness are part of law more generally, not just as part of administrative law, but also in torts and in contracts. We have standards of rationality in many areas of law. But things get complicated, more complicated, when it comes to policy decisions. What is the standard of reasonableness under which we should review a decision of the Ministry of Interior or of the Ministry of Health? For example, how can we tell whether when the Minister of Health, here the Secretary, right, makes a decision regarding a global pandemic and chooses among different options, each of them uncertain, meeting with challenges that the technology really develops on a day-to-day basis, can courts actually be the best arbiters or the best reviewers of the reasonableness of government decisions? And when you come to think about what modern states look like, the scope, the range of fields that different cabinets have to take, have to become experienced and an expert in. If you're thinking about the immense range of administrative decisions that are made on a daily basis and the expertise and professionalism needed in order to master these fields, it quickly becomes apparent that much of this expertise and professionalism and experience are something that courts not necessarily have and are not necessarily the best decision makers as reviewers of these decisions. So again, we connect here to a very deep controversy, and there were many efforts to limit the ability of courts to conduct reasonableness review of government decisions over the years. I'm proud to say many of the most sound critiques came from Hebrew University Law School, not from myself. I was still a student back then. But my colleague, Professor Yoav Dotan, has been one of the first critiques of this doctrine. So we see there are reasonable grounds to think that courts might not necessarily be the best reviewers of reasonableness of government decisions. But what the current bill that's about to get legislated, if nothing changes by tomorrow, seeks to do goes over and beyond what anybody ever thought should be the limits of the reasonableness doctrine. So if we're trying to understand why people are now on the streets, I'm now going to delve into the sort of first reason, which is the content of the bill, this specific bill that will be legislated tomorrow itself. So what does it set to do? So there were lots of ideas in the past to get the court to use the reasonableness test more narrowly, to save it as like means of last resort. They have other ways to review government decisions. What this current bill sets to do is to prevent courts from ever applying any test of reasonableness to any government action. This has several concrete worrying features into it. First, under Israeli law, almost every minister who's part of the Israeli cabinet is authorized not only to make policy decisions like what to do with a pandemic or what kind of public transportation Israel needs in a certain area or everywhere, but also hundreds of decisions pertaining to individuals, individual people, individual businesses. There are lots of specific authorities given by the Knesset to specific ministers that are not defined or constrained in any ways. The minister should just make a decision. The Knesset did not provide an overarching guidance as to how to do that. The current bill does not stop in saying, the courts are not experts enough to judge the reasonableness of policymaking. It goes on to influence every decision a minister could conduct with respect to individual people, even though these are decisions where we would need reasonableness the most. In brackets, I will say that there were proposals for the committee in the Knesset to maybe just shrink reasonableness back to arbitrary and capricious. It's sort of most common law version. The committee rejected them. So if anybody would look at the sort of proceeding of how this law was legislated, it's clear that the government doesn't want even the arbitrary and capricious standard. It doesn't want any review of any parts of reasonableness of decisions, whether it's regard to policy or with regard to individual decisions. The second very contested hot-button issue that this bill, once enacted into law, will influence is appointments. You might have heard something about that. So Israel is one of the only democracies in the world where there is no additional oversight on executive appointments, right? So again, it's sort of easy to draw inferences or to compare it to how things are conducted here. When President Biden or President Trump or any other president want to appoint someone senior to the executive, what do they need to do? It's true for Supreme Court justices. It's true for members of Mr. Biden's cabinet. It's true for senior, high-ranking executives in general. They need to go to Senate. So you appoint somebody and you get them confirmed by another directly elected institution. This is actually very prevalent in most democracies. Everybody knows that people appointed to senior executive functions hold the keys to huge responsibility, money, power, and therefore we want to have some kind of review to make sure that these people are worthy of the responsibilities we're giving them. In Israel, we don't have any such outside review process for any senior appointment except for the ministers of cabinet themselves who are approved by the Knesset. Remember, in order to start a government, you have to have a coalition in the Knesset. So it's not a big deal to get the approval of the Knesset for ministers of the cabinet. But other senior appointees never have to go through any outside overview of their candidacy. This role, in my opinion, not in the best interest of either the court or the appointees themselves, was conducted by the Supreme Court in the past 25 years. So the court, under the reasonableness doctrine, had reviewed in response to petitions all kinds of appointees, from ministers in the cabinet, like former Minister Aryeh Deri from the Shas party, whose appointment was challenged several times before the Supreme Court because of corruption, indictment and then verdicts that he was involved in, but also other high-ranking non-elected executives. The appointments of was challenged under the reasonableness doctrine. The specific bill explicitly says no review of any appointment is to be conducted by the court from this day forward. Now, what you can see here, I think, pretty clearly is it's very likely that the court is not the best reviewer of government appointments. Maybe a model like, the president and the Senate, or some other sort of elected committee that will somehow be formed in the Knesset with a hearing or something. We could think of other models to review the appointment of senior executives. The problem with the current bill is that it removes the only check, however imperfect it was, that was there in the Israeli system, that was developed on senior appointments, and just does not introduce anything else in lieu of that. Professor Netta, for example, and myself have proposed to form an ethics committee that will be entirely composed of Knesset members, just to have a procedure by which it will be publicly shared, the candidacy, the record of the candidates. We will know who they are. We will be able to have a process by which the Knesset reviews their candidacy. All elected, non-judicial. The committee rejected that as well. In fact, the law entered into the committee and left the committee entirely unaltered, except for two changes introduced by Yariv Levin, Mr. Levin, and M.K. Rothman, who heads the committee on behalf of the coalition themselves. So none of the experts or the opposition comments and proposals that were heard during those 3 weeks, none of them was able to somehow be accepted and somehow modify or change the content of the law. So when we're trying to understand what happens today in Israel, why people are on the streets, why there is such big controversy around a topic that sounds pretty technical, and actually, it's not the first time there were critiques on the reasonable, so the first reason why people are upset is simply the radical direction by which past proposals to limit reasonableness and its use by the courts has taken shape in this specific bill. The second reason why people are concerned, and you hear that a lot in Israel these days, both by the opposition and by the protesters, is what we call in Israel the salami method, or the concern that, remember, Minister of Justice Levin put on the table on January 4th a 9-item plan. This is only one part of it, and that plan was supposed to be part of a 4-part plan. And so people are asking, if the coalition government is willing to push forward this piece of legislation against all this protest without actually revising the content of the law in order to make it adjusted to the kind of concerns about removal of checks and balances without introducing new checks and balances, what kind of guarantees we have that this will not continue to items 2, 3, 4, and so on in the original Levin plan. So this is viewed as sort of the first actual step of something that's much bigger than that, of the entire package of Mr. Levin's suddenly now getting legislated. Now, the third, and I think that without the third element, and I think that without it, we really can't actually explain or understand what's going on in Israel these days, is that what started as a legal controversy and was really a legal controversy and a legitimate legal controversy on January 4th and in the 25 years before that, has long stopped being a legal controversy and has really morphed into the biggest social, political, economic, security, and even diplomatic crisis that we've had, especially in this form, with all of this sort of mingled together, probably the most severe crisis we've had in Israel since our founding in 75 years ago. And this is a tough competition because we've had many crises and many of them were very severe. And maybe what we're seeing now is really just the culmination or the aggregation of our previous efforts or previous suppression of these previous crises and our inability to take good care of them, to do the proper maintenance, if you will, and this just now exploded on a large scale. So to put it in other words, whatever we have been able to just sweep under the rag for 75 years, it all came out in the past months together. So different narratives about the separation of temple and state in Israel and the relationship between religious and secular Jews, different visions about the relationships between Israel and its Arab neighbors, and particularly the Palestinians, that also takes center stage in the protests, and it also animates a lot of what the government seeks to do with these new powers with respect to the West Bank and how things will be carried out there, and the project of Israel's defense and settlement projects more generally. This has become also a huge economic crisis in the very simple sense that ever since it started, the Bank of Israel sees a massive flow of money outside of Israel to banks in Europe. And as compared with previous years, really decade, where Israeli startups all opened and registered themselves and their business in Israel, since the January 4th, not even one startup registered in Israel. There were a few dozens that registered. They all registered here in the US. So businesses are escaping, and we also see a stop in investments by outside forces. Of course, everybody talks about a slowdown of the high-tech industry more generally. We must remember it might be part of it. But some analysis of Israel's Ministry of Finance show that the Israeli startups took a larger hit than their comparables in Europe and in the US, whereas in previous years they led the investments. And as you know, we have something of a diplomatic crisis as well with our relationship with the United States and with other democracies seeming to be in danger, or at least tensed by this controversy. So the bigger picture is that in many ways, even if we were able to find a solution, a reasonable solution to the reasonableness crisis now, it will probably not be enough to heal the broader crisis that we have now in Israel, where large segments of the population from both the right and the left feel that the basic social contract has been eroded, is being torn, and they have lack of confidence in their ability to live together in the same land and the same country. And I want to emphasize, these are not feelings that are only shared by the protesters. These are often feelings and sentiments that you hear by people who strongly support and have been supporters of the reform, of some reform, for 25 to 30 years. These people also feel that what's going on in the streets now and the ways that the chosen legitimately elected coalition is unable to pursue its agenda, and that large segments of the army are refusing to serve or continue volunteer to serve, that is also an erosion of Israel's social contract. Okay. So what can we do? So we now get to the third part of my talk today, and which tries to suggest a path forward. What I and several colleagues of mine have been working on since mid-March 2023, really since that major event where Minister of Defense Yoav Gallant was fired, and it became clear that we are in a much, much, much bigger crisis than what everybody maybe have suggested or thought before. We have been trying to propose a democratic solution to Israel's democratic deficiency at present. And it builds on these really two main assumptions that we have been working with since the beginning of this talk. First, we are in this very, very big social crisis that has long exceeded the simple legal controversy. And second, as we've seen for the past 7 months, what typically democratic societies do when they have such fractures, they try to negotiate and broker agreement in their political system, in their democratically elected system. But our democratically elected system has proven itself unable to produce the healing necessary. And I want to be crystal clear. Even if the coalition government succeeds, and it will probably succeed, in passing this legislation tomorrow, and it certainly has the votes to do so, as far as we know, it will be able to technically finish the legal business, or at least one part of, but it will not be able to heal the social covenant that has been fractured and eroded. In fact, this piece of legislation, by all means, will probably just deepen the fractures and make them harder to mend. At least this is what we see currently. So if we have a severe social crisis that's about the social covenant, the basic social covenant, people's ability to live together, and our democratic institutions are unable to do that, what me and my team are proposing to do is to form a democratic institution that will be able to renew or rejuvenate Israel's social contract. We propose to revive Israel's Constituent Assembly. The Constituent Assembly, this name, this term, is not our own invention. Maybe some of you know that there is a long-forgotten paragraph in Israel's Declaration of Independence, after all of those parts and paragraphs that people like to quote, that says that the first elections in the new state of Israel will be held for electing representatives to the Constituent Assembly, in Hebrew, Asefa Mechonenet. Okay? Here you're used to thinking about a constitutional convention. The Constituent Assembly, the Declaration of Independence, envisioned to be a body, not just a delegation of representatives, but a body, an elected body, that will give a constitution to Israel. Now, these elections were held. They were held in 1949, a bit of a delay of schedule. There was a war of independence, but they were held. And the first Constituent Assembly decided after 5 months that it's not going to write a constitution for Israel. And they had good reasons to do that. Okay, we could talk about some of them in the Q&A. We're not judging them for the decisions they made. They were clearly good and valid for many, many decades. They decided they're going to change their name to the First Knesset, and that the authority to write Israel's constitution will be transmitted from one Knesset to the subsequent Knesset until all chapters of the constitution will be written, and then Israel will have a constitution. And the Knesset has done exactly that over the years. It had legislated more than a dozen basic laws, chapters of Israeli constitution, but it had never finished the task. And as we see, even what the Knesset legislated till this date is now hugely controversial. And many segments of the population lost their faith and trust in the basic structures that we have, and these structures are now under incredible tension. So what we propose to do is to revive the Constituent Assembly. Briefly, what we offer is to have a new body of 100 members, a third of which elected by the current Knesset, by the different factions in the Knesset according to the relative strength. 2/3 will be elected by the public directly in elections that were not held in Israel since 2049, elections that will be entirely designated and entirely dedicated to the question, what should Israel's basic rules and structure of government be? And what we propose is not only that this new body will be formed of new politicians, but also that the kind of politics they will engage in will not be Israel's typical politics of building a narrow coalitions, deciding by a bare majority, but striving to achieve consensus between the different factions, guaranteed from, if you will, from the bottom, by a 2/3 rule. The two-thirds rule is a very common rule in constitutional processes, and specifically in Israel, it's super important because we know we've had enough elections in past years to know that this number guarantees that the kind of majority that the Constituent Assembly will have to form will necessarily cross the sort of traditional camps and divides in Israeli Knesset. So it will have to be a broad consensus on these rules. And we don't stop there. We propose a whole system, supporting system of procedures and rules that are supposed to help them reach consensus. I know to some of you, reaching consensus, especially in Israel, sounds pretty idealistic or maybe naive, but there is international and comparative experience we're building on. Israel is not the only fractured society in the world that was able to overcome its divides, even much stronger and more violent divides, and to write a constitution that lasts. We have quite a few examples to draw on, both successes and failures, from South Africa and Ireland, lately to Chile, that's still managing their constitutional crisis. And we have been, in those past months, interviewing former ministers and current ministers of justice, politicians, constitutional experts all over the world, and learning from this experience and matching it with ours. I'll say just one last thing. This proposal has now been out on the public table for the past 2 weeks. Prior to publishing it, we have conducted many discrete behind-the-scenes conversations about it with senior-ranking members of the political system. We have been receiving a lot of support in the past 2 weeks from both the right and the left, which is encouraging in and of itself, as well as criticism from both sides since it was published. Prime Minister Netanyahu knows about this plan. Several different people in his camp brought it to him. There are senior members of the opposition who support this plan, and I have no guarantee or ability to project whether there is any actual likelihood that it will come to be. So we can talk about the political question in the Q&A, but what I want to leave you with is that regardless of how deep and worrying and concerning the current political crisis is, and we do need a few responsible adults to take us out of it, we need a solution for the big crisis that has long exceeded the specific controversies on legal or constitutional issues that this government had put on the table, but has engulfed all kinds of conflicts about the shape of Israel and the relationship between its factions. So whatever solution will be formed, even if it's not the Constituent Assembly, it will need to be something similar to the Constituent Assembly in order to help us breach those divides, mend the social contract, and be able to start the next 75 years on a much more stable basis than we are at now. Thank you.